minutes to come in, and we have a number of people we're admitting into the room. So we're going to begin in a couple of minutes. Thank you so much for your patience. Welcome, everyone. This is the welcome everyone to the panel, Applications of the Principles of International Humanitarian Law to the Current Conflict in Israel, Gaza. We're going to give everybody about another minute to get into the room, and then we're going to begin. Thank you for your patience. Good morning, good afternoon, and good evening, everyone. Welcome to the American Society of International Law, Liber Society's panel, Applications of the Principles of International Humanitarian Law in the Current Israel-Gaza Conflict. This event is co-sponsored by the DC Bar International Law Community, comprised of over 1,500 lawyer members across the country and the world with interest in the fields of international law. I am Marianne McGrail, a member of the Executive Committee of the Liber Society. The comments I make are made by me as an individual and do not reflect the views of any institution or organization. The Liber Society serves as ASIL's focal point for the study and dissemination of the law of armed conflict, ASIL being the American Society of International Law, or international humanitarian law and other public international law related to the conduct of military operations. The Liber Society facilitates dialogue by bringing together academics and governmental and non-governmental practitioners, civilian and military, from the United States and throughout the world. Through these efforts, the Liber Society strives to promote understanding of, respect for, and compliance with international law. We will have brief initial remarks from all five of our very distinguished panelists in response to questions, which I will read in a moment for the audience, and then we will proceed to discussion. We will leave about 10 minutes at the end for Q&A from the audience members. If you have a question for any specific panelist or for the panel in general, please put it in the Q&A. Type it into the Q&A function, which you can find that button at the bottom of your screen. Just a reminder that this is intended to be a civil and respectful conversation about difficult topics, so we ask everyone to refrain from interrupting others while they speak and to treat others with civility and respect. So the five questions that the panelists have carefully considered and have expertise on are: first, is this an international armed conflict or a non-international armed conflict? And how does Israel's declaration of war affect that analysis? Second, when combatants are embedded in a civilian population, how do such principles as distinction and military necessity and proportionality apply? Third, what are the requirements for treatment of hostages or prisoners of war? How should those being held by Hamas be characterized? Four, who is considered responsible for providing the necessities of life, food, water, medical supplies to civilian populations, and who is responsible for the evacuation of civilians? Finally, we may discuss definitions of war crimes, how you define them under international humanitarian law. I'm very pleased to present, first of all, the chair of the Executive Committee of the Liber Society, or the chair of the Liber Society, Professor Shiri Krebs of Deakin University. She is currently an Alexander von Humboldt experienced researcher at the University of Hamburg, as well as an affiliated scholar at Stanford University Center for International Security and Cooperation. Shiri, please go ahead.
Thank you so much, Marianne, for organizing the panel and for this very helpful introduction. Thank you to all the panelists for taking the time in very different times of their day to join us today, and to everyone else joining us, listening and joining the discussion. So I will start with a few broad comments. I think we have a very kind of intense agenda, and I don't want to start by kind of grounding our discussion with some answers. So I think I'll start with perhaps more questions or issues to think about with regard to how we address IHL questions more generally today, and with regard to this conflict and others. So I wanted to start by saying that in Australia, we open every event by acknowledging and paying respect to the traditional custodians of the land, skies, and waterways on which we gather, on which we come together. And I've always found this custom very humbling as a reminder to open my mind and heart to thousands of years of learning, dreaming, and knowledge that is very different to my own or from my own background. So the issues that are the core of our discussions today are fraught with intense disagreements, including some of the very core facts which form the basis for any legal analysis. And so I really hope that together we will be able to discuss these issues with mutual respect, but also with a way that can perhaps shed some, come to some agreements with all that kind of broad disagreements that are deeply political and politicized. And I wanted also to frame our discussion with some words from Israeli poet Yehuda Amichai, who once wrote that out of 3 or 4 in a room, one is always standing by the window, forced to see the injustice among the thorns, the fires on the hill, and people who left whole, brought home in the evening like small change. So my aim, at least, in joining this panel today is to stand by the window and to look straight at what we see there. And perhaps because I think for me, this poem always kind of was an invitation to think about how different people stand by different windows, seeing very different things. So I hope that we manage to kind of stand by the same window and see all the suffering that is outside our window. And by saying that, I also hope that we will treat IHL in our discussion today, and hopefully even more broadly, as what it was intended, I mean, putting cynicism on IHL aside, to protect people and to prevent or mitigate some of the suffering that happens during war. And so I hope that what we can do today is think about the suffering of both Israelis and Palestinians today in Israel and in Gaza. Personally, I think that a few or 3 of the most important issues at the moment within that conflict or framework are the hostages that are held by Hamas within Gaza. I have personal friends whose children are currently young children held on their own within Gaza, and the parents know nothing about their whereabouts. I found this as a parent completely unbearable, even though this is, of course, and I think, I mean, not even though, I think this is completely unbearable and intolerable, period. So I think that is one issue. I hope, and I don't know because we haven't considered this together, but I think I find very little way to justify any of those actions under international law. So perhaps it won't be the core of the discussion today unless someone wants to say things otherwise. But I wanted to start by putting this out there as one issue that is current, a suffering that is going on, and that we should look at it and think what should be done. The other 2 issues that I think at the moment are particularly burning or urgent are Israel's suffocation of the Gaza Strip, mainly preventing electricity, food, water that would allow the population in Gaza to survive. The other one that I think could or is in opening a legal front, perhaps, is the issue of the Israel's call for evacuation of civilian population from north to south Gaza, which I think that, and I think there, and I already read so many debates about the legality of such an order. Personally, I think that an important way, and I know that Omar Dajani is planning to contextualize our discussion historically, but I really think that I find all the discussions that are very kind of strictly legalistic around this conflict somewhat unhelpful, because we can't look at the things or examine the legality without looking specifically into their context and into the facts on the ground and into what they mean with regard to the life of actual people. And so I think we can say what we want legally about that, evacuations may sometimes be lawful under international law. The real question is not whether evacuations may sometimes be lawful under some conditions, in some circumstances under international humanitarian law, but specifically whether in the conditions currently in the Gaza Strip, whether people can temporarily be moved from place A to place B in a way that protects their life and dignity. And so I hope that within our discussion, we can put civilians, or we can put people at the core of our legal thinking, and thinking about the context and what each kind of legal mechanism means in the context of this war. So I think I'll end my kind of introductory broad comments here, and I'll come back at the end of the panel with some, once we kind of have a deeper understanding of where everyone stands and whether there are some ways where we can come together, or some disputes that we want to sharpen a little more. Thank you very much.
Thank you so much, Shiri. That was a wonderful introduction. Many excellent observations. Our next speaker is Professor Omar Dajani of the McGeorge School of Law, University of the Pacific. Previously, he served as legal advisor to the Palestinian negotiating team in peace talks with Israel, and much of his scholarly work explores the implications and influence of international law with regard to the situation in Israel-Palestine. And I posted the initial questions in the Q&A for the audience members. Professor Dajani.
Thanks very much, Marianne. Thanks as well to Shiri for bringing us together this morning, and to ASIL, of course, for convening. I really appreciate the effort to have a focused conversation on the many IHL issues that are arising that have arisen in the weeks since October 7th. I'd like to address my opening comments to 2 points. One, in relation to the issues posed by Marianne in her second question around how distinction applies in a context of urban warfare. And the second, applying both to that question and to the issue of war crimes. I realize that it has become controversial these days to speak about context, but I think, as Shiri pointed out earlier, context is crucially important. And one of the issues that will have to be resolved, both as we determine the extent to which Israel in the Gaza Strip has fulfilled its obligation to distinguish between civilians and military objectives, and as we assess whether war crimes are committed, is what the intent behind the specific military actions that Israel has engaged in over these weeks was. As we think about what the intentions behind these actions were, I think that it behooves us to look at a longer scope than just the last few weeks. Much of the strategy that we appear to see unfold that it appears to have unfolded over these last few weeks is familiar to those of us who have watched this conflict. And in particular, those of us who have watched Israel's military operations, not only in the Gaza Strip over these last 5 wars, but also in southern Lebanon. And there is, I think, a need at this juncture for us to pay attention to what Israeli leaders in the past have articulated their aims to be, and to compare those articulated aims with the consequences that we see on the ground in the Gaza Strip and elsewhere. And so I'd like to bring into the conversation a doctrine that has been much discussed in the past, though it's maybe been relabeled in the last year or so, which goes by the name of the Dahiyah doctrine, referring to a neighborhood in southern Beirut that was the focus of Israeli bombardment during the 2006 Lebanon war. And the Dahiyah district was effectively flattened during that war. And in the context of those hostilities, there was a lot of discussion about what the aims behind Israel's actions were. And in 2008, a leading voice in the Israeli security establishment, who was advisor and head of the IDF's planning branch at the time, Major General Yora Island, articulated a doctrine which came to be known as the Dahiyah doctrine, in which he emphasized that the civilian population should be made to feel the brunt of the military operation and made to feel the consequences of Hezbollah attacks upon Israel. As he put it, there will be no recurrence of the situation where Beirut residents go to the beach and cafes while Haifa residents sit in bomb shelters. And later, another Israeli general, Gadi Eiskenot, explained Israel's conduct of the Lebanon war by offering a chilling warning. He said, what happened in the Dahiyah quarter of Beirut in 2006 will happen in every village from which Israel is fired on. We will apply disproportionate force on it and cause great damage and destruction there. From our standpoint, these are not civilian villages. They are military bases. Now, when we look at some of the rhetoric that has emerged in the last weeks, what we see is a very worrying echo of statements of that kind. The IDF officials stating that the emphasis today is not on damage, is on damage, not accuracy, stating that Gaza will eventually turn into a city of tents. Israel's economy minister saying there will be no buildings. Now, I mention all of this because as we undertake to ascertain the extent to which Israel is actually pursuing military objectives other than applying disproportionate force in a way that might deter future attacks from Israel's perspective, I think that it's really important for us to pay attention to what Israeli leaders have said and to compare that to what we see unfolding on the ground, the sheer scale of damage that we are seeing unfolding there. The second point I'll make very briefly, and I know that our time is limited this morning. Proportionality is a necessary part of the assessment of the lawfulness of Israel's actions in the Gaza Strip, just as distinction is. And in light of some of the public discourse about proportionality that we have seen, I think it's really important for us to remember that what we are ascertaining is not the extent to which we see the Israel's actions in the Gaza Strip as proportionate to what it suffered on October 7th and October 8th. I have joined many others in speaking clearly and with revulsion about what happened on October 7th and October 8th. It was an atrocity, and I don't think that we lose anything by saying that forthright. But proportionality analysis does not compare what happened with what should happen. As Sari Bashi, an important voice at Human Rights Watch, has pointed out, there is no right to respond with civilian casualties proportionate to those that have been suffered by Israel. What we need to focus on instead is the extent to which these civilian casualties are proportionate to Israel's objectives, military objectives on the ground. And here, I think we have heard too little that is specific about what those objectives are. We have to bear in mind, with respect to rocket attacks, that though rockets have proliferated, casualties from them have been small. Over 20 years, less than 100 Israeli deaths. And I'm not saying that those deaths are justified or that the rockets are not indiscriminate. But I think that we also, when looking at the scale of damage, almost 7,000 Palestinians in the Gaza Strip killed in the space of 3 weeks, we have to ask, is that proportionate to the threat presented by these rockets? And similarly, as we look at some of the important evidence that organizations like Human Rights Watch, Amnesty International, B'Tselem have brought to bear on this, where they have sought to find some military objective in the rubble of Gaza City, we've got to be emphatic in holding Israel to articulating with specificity what its military objectives are, because otherwise proportionality becomes, as Marty Koskaniemi has put it in the past, an endlessly elastic framework. Thanks very much.
Thank you very much, Professor Dajani. Our next speaker is Christian Jorgensen, who is an international humanitarian law legal advisor for the American Red Cross National Headquarters in Washington, D.C. His early professional and academic work focused on public international law, including international human rights law and refugee law, and he worked on asylum cases in the UK and is a past international legal fellow for De Justicia, a legal think tank in Bogota, Colombia. Christian serves also, in addition to his work for the Red Cross, he serves as co-editor of the monthly refugee legal newsletter, Rights in Exile. Christian.
Thank you, Marianne. And, I appreciate the opportunity to contribute to this critical discussion on IHL within this really challenging context that is extremely challenging for many people for humanitarian reasons, but I've also just seen it very challenging for public discourse on this topic, more so than other conflicts recently, which isn't to minimize other conflicts, but it's to show the importance of true understanding of what the IHL principles are. And so as a representative of the American Red Cross, we're a neutral organization to the conflict. And so there might be some things during this conversation I can't speak on, but I will do my best to speak on things in the most neutral way that I can, if appropriate. But I'd also like to stress that our organization is merely just one component in a larger humanitarian network. So our mission extends beyond merely promoting legal compliance with IHL. We aim to underline that these legal frameworks serve moral imperatives that we all must uphold. And I think part of that is having this discussion today so people can uphold these principles in society as well. So these principles include distinction, proportionality, humanity, and military necessity. And these aren't just legal requirements, they're ethical standards designed to minimize the devastating human costs of armed conflict. So when we talk about these principles and we contextualize them in a way that supports our side, or we ignore them, it contravenes not only international law, but also has ramifications that reverberate across the globe, both politically, but also for the work that humanitarian agencies are doing. It makes it incredibly difficult when we for them to do their job and to get the trust that they need to do their job. The other thing that I'd like to talk about is that we must recognize that civilian rights and protections are non-negotiable in any armed conflict. This holds true for all parties involved, which sometimes I've also seen during the discourse that we often focus on, one side not doing this over the other. And so it's very important that we continuously talk about the obligations of both sides to a conflict. And so one of the most challenging applications when I think about civilian rights and protections does occur to your question when combatants are situated within civilian populations, which I also think, yes, that I'm not saying that it is in this instance. It could be a strategic decision, but it also could just be the nature of, the ground of where that conflict is taking place. But it is a very challenging, it's a difficulty to apply the principles in these situations and to promote civilian protection while still recognizing the reality of the law. But nevertheless, in these, like the situations where combatants are in the ground with civilians, IHL's principle of proportionality stipulates that civilian harm must not be disproportionate to the military advantage gained. However, but you can't just say that statement and then just stop there. You have to also continue on explaining that to people so they understand that it's assessed in real, like the principle of proportionality is assessed in real time. It's not done in hindsight. It places a very high responsibility on the commanding officer to make this decision with the information available at that time. And it's necessary to recognize that it's difficult to determine if something is proportionate or not proportionate, because although we might be immediately aware of the information following a decision to launch an attack or a targeting operation, we're not privy in most cases to the information on what that decision is based. And that's really important to make a legal determination if something is a violation of legal proportionality or not. So I just think it's important to note that when we speak about proportionality, we make those intricacies clear. And the last thing, I just want to go back that, the public narrative around these issues, in my opinion, something I hope that we achieve today is I think that it simplifies IHL into a generic term of rules of war. I've heard that so many times in the media, and very rarely have I seen them bring someone on to explain to the public what the rules are. And what this does, in my opinion, is it obscures the complexity of these laws. And it might, in some cases, for some people, allow them to interpret that they're flexible or they're contextual, or, I've seen many people say that they're not worth anything at all. So I hope our discussion provides some clarity on that today. So I think it's our job to demystify these principles for people in this discussion today, and foster a greater public understanding of what IHL really entails, especially when it comes to things like distinction and proportionality, and even talking about what military necessity says in certain cases as well. So it's not an easy thing, especially when we're in such a fast-paced information landscape today. But I hope that we're able to accomplish that today in the discussion, and I look forward to being a part of it in the best way that I can.
Thank you very much, Christian. Our next speaker is Professor Omar Shakir, who serves as the Israel and Palestine Director at Human Rights Watch, where he has authored several major reports, including a 2021 report comprehensively documenting how Israel authorities are committing crimes against humanity. As a result of his advocacy, Omar left Israel in November 2019. He's also covered Egypt for Human Rights Watch, represented men detained in Guantanamo Bay, and co-authored a report on U.S. drones in Pakistan. Omar.
Thank you so much, and thanks for everybody for organizing this. I think a lot of really important insights have been shared. I'll try and sort of synthesize Human Rights Watch's analysis about some of the legal obligations and where they're being violated in the current context. And we'll just do so in a quick way to allow us to get to our discussion, and happy to dive much more in the discussion. So, just sort of talking about the recent context, and Shiri started us off there. It's very clear, and this should be obvious to anyone who's, on this call, deliberate killing of civilians is a war crime, and Human Rights Watch has verified videos is investigating the October 7th attacks, and they clearly amount to war crimes, deliberately killing civilians, firing into crowds, going into people's homes, deliberately shooting them. That's straightforward. Hostage taking is also prohibited. It is a war crime. It's under the Common Article 3 of the Geneva Conventions. There's very clear definitions. The ICRC has also set out a very clear definition of what counts in their commentary on Article 3. It's quote, the seizure, detention, or otherwise holding of a person accompanied by the threat to kill, injure, to continue to detain that person in order to compel a third party to do or abstain from doing any act as an explicit or implicit condition for the release, safety, or well-being of the hostage. So that's also a war crime. We've called for their immediate and unconditional release. At the same time, collective punishment, so punishing an entire civilian population for the acts of individuals, is clearly a war crime under international law. And so that's how we've characterized the Israeli government's decision to cut electricity, water, to block the entry of aid, of fuel that's necessary to run generators that are important for the hospitals and elsewhere. We've called that, determined that's collective punishment, which is a war crime. Atrocities by one side do not justify atrocities by another party to a conflict. The obligations of international humanitarian law are not a deal between fighters. They are an agreement with humanity. We also characterize the deliberate impeding of aid supplies of food, water, medicines to be a war crime. International humanitarian law does not prohibit sieges or blockades, and certainly a country has the ability to inspect, but not to deliberately block entry of humanitarian aid. The trickle of aid that's coming in currently through Egypt, as the UN has said, is insufficient to meet the needs of the civilian population. Starvation as a weapon of war is also a war crime. So, the next thing I want to sort of talk about is the airstrikes. And obviously making determinations about legality of particular airstrikes, as Omar noted, is a difficult thing to do in the heat of the moment. Human Rights Watch is investigating. But there are some things that we can say based on the work we've done. First of all, we have documented the use of white phosphorus in densely populated areas, which is unlawful. We also have raised grave concern about the use of explosive weapons with wide area effects in densely populated areas. We have also raised concern about indiscriminate rocket attacks by Palestinian armed groups towards Israeli population centers, some of which have, misfired and killed Palestinians in Gaza, as we've documented. Human Rights Watch we've been involved in documenting abuses in prior rounds of hostilities. We've documented Israeli airstrikes that wipe out entire families, that destroy entire high-rise buildings with no apparent military target in sight. We're already seeing evidence of strikes that wipe out entire city blocks and reduce large parts of neighborhoods to rubble. Again, they raise significant and grave concern. We've also documented in the past indiscriminate strikes, deliberate targeting of civilian infrastructure. So war crimes committed both by Israeli authorities and indiscriminate attacks carried out by Palestinian armed groups. All the evidence we've seen so far suggests those patterns are continuing and potentially at an even more alarming scale. In terms of what Shiri mentioned on evacuation, so that's I should have noted much earlier, of course, Human Rights Watch considers Gaza to be occupied territory. We do so by the virtue of the test of primary control. The Israeli government controls while they withdrew its settler population and ground forces in 2005, they retained control over the airspace, the entry of infrastructure, the population registry that controls the issuance of IDs, the movement of people and goods, the collection of taxation. That's why this test of effective control is why Human Rights Watch, the ICRC, the UN, and many others determined that Israel still has the obligations of international humanitarian laws and occupying power. So when it comes to evacuation, we have said that's only permitted in a context like this for security of civilians and for imperative military reasons. Folks must be allowed to return as soon as possible. If not, that would amount to forced displacement, which is a war crime. We've also said that the obligations of distinction still apply. One cannot assume that those who are unable to evacuate suddenly become legitimate targets. All the duties of international humanitarian law continue to apply to those that are there. And maybe to sort of conclude these introductory remarks, to say something about The point that obviously the violence and repression did not begin on October 7th. That is not to justify. Again, there's no justification for Hamas heinous attacks. Gaza has been under an unlawful closure, a generalized travel ban on the movement of people or goods for 16 plus years. That led to a reality of the civilian population. And again, generalized ban on travel, not a specific security-based restriction. In the West Bank, we know there have been settlements, which are, violations of the Fourth Geneva Convention. There's been, displacement, home demolitions, which amount to forcible transfer, which are also war crimes. Human Rights Watch, Amnesty International, Israeli and Palestinian groups have also found that Israeli authorities are committing the crimes against humanity of apartheid and persecution against Palestinians. So best to understand that no justification for what we're seeing since October 7th, but important to understand the larger context in which these events are taking place. We have seen systematic abuses of international humanitarian law by all parties and human rights, and impunity for them is why we're here. I'll stop here and look forward to the discussion.
Thank you very much, Omar. Ido Rosenzweig is the Director of Research for Terrorism, Belligerency, and Cyber at the Minerva Center for the Rule of Law Under Extreme Conditions at the University of Haifa in Israel. Professor Rosenzweig.
Professor, well, thank you for the promotion. Thank you, Marianne. Thank you, Sherry, for inviting me, and thank you for us for organizing the event. I want to start a little bit with a personal perspective, and then I will go into the framework. And one caveat, which I generally hope I will not have to use, is the fact that there is a small chance that we'll get a siren in the next 20 minutes, and then I will immediately have to leave, and I do apologize if that happens. On October 7th morning, we woke up for such a siren in the middle of Israel, just outside Tel Aviv. And the immediate thought we had at home is whether or not the tickets that we have to see Bruno Mars that evening are going to be canceled or not. Little that we know what we're going to wake up to. It took us a while to get a grasp of the atrocities and the horrible things that happened during that day. The shock, the horror, the stories we still hear about things that happened there, how people survived, and how people, what happened to people, how people, young children, families were completely slaughtered or burned to death. And that has a very, very strong impact on the reaction of the Israeli population to what happened from that day. And there is a very strong gut feeling about what happened and how people should react. But at the same time, we know that gut feelings are not what's supposed to guide you when you are using armed force. So any messages that were taken during those days, I would consider them as the immediate response, but not necessarily the guidance, and especially not the operational guidance to the military on that time. And we still see a lot of those responses on social media and in the public, but you see them less and less from the heads of states, the cabinet members, and you see them less. Of course, you don't even hear them anymore, or even if you heard them to begin with, from the IDF commanders. And that being said, clearly this is an armed conflict, and situation of an armed conflict. There's a big question whether or not we are in a very long armed conflict, ongoing armed conflict. As Omar Dajani has mentioned, there is the historical context that are we in an ongoing armed conflict between Israel and Gaza, or specifically Hamas, that has high threshold and low threshold, and therefore any question of jus ad bellum proportionality is redundant, or are we have segments and each round has its own question, and then proportionality, jus ad bellum proportionality has to remeasured to begin with. I don't think that within a panel on IHL we need to focus too much on jus ad bellum proportionality. I will say, and I think might be a minority in that position within that panel at least, that I don't think the Gaza Strip is under belligerent occupation by Israel. I think that the belligerent occupation ended in 2005, in September 2005, when Israel disengaged from the Gaza Strip. The two main concepts of belligerent occupations are boots on the ground and effective control. And once Israel disengaged from the Gaza Strip, it has no boots on the ground. IDF has no boots on the ground in the Gaza Strip. And as you can see on a daily basis, effective control is nothing that Israel has over the Gaza Strip. You might argue some functional responsibilities with regard to electricity and water and food, and where Israel has control. It also has a naval blockade over the Gaza Strip, so it has that responsibility as well. But within the framework of belligerent occupation and the entire set of rules that derives from that, I don't think is applicable. And without taking much of my introduction time, I will also say, before we go into the Q&A part, that there is a very strong tendency to not only have a context-based analysis, as Omar Jani suggested, which is important. You need to analyze the situation in accordance to the context and the reality of the situation and the historic and whatever happens there. You need to have that in mind. But I think we also see a lot of agenda-based analysis on certain of the aspects, and sometimes there is a tendency to jump into conclusion based on your opinion or your personal position. And I'm not saying that people don't have personal position or personal opinion over the matters. Surely I do, as someone who lives there and live that conflict on a daily basis. Don't necessarily agree with 90% of the things that are doing on my behalf, allegedly by the Israeli government throughout the years. But it doesn't mean that we can jump to a conclusion that a violation of international humanitarian law has taken place where some more information is needed. So if we, for example, just because you've mentioned that, Omar Shakir, you mentioned the fact that there were targets that Human Rights Watch was unable to find what was the military objective there. The fact that you are unable to find that doesn't mean it doesn't exist. It means that IDF is required to explain that position. But we cannot jump to that conclusion that a war crime or a violation of international humanitarian law has taken place if we don't have the full information. What we have is suspicion that requires more information, and we ought to demand that information from the IDF and the Israeli government. Yeah, I will stop it at this point because we want to have more questions and discussion. Thank you.
Thank you very much, Dr. Rosenzweig. Sherry, you would like to make some more comments. Please go ahead.
Thanks, Marianne. I'm happy to just maintain my kind of comments to the end if we have some questions or issues that we want to focus on, or questions from listeners. Otherwise, I'm happy to continue with the few comments that that are based on everyone else's thoughts.
Well, everybody has raised questions for me, but I'd like to hear some more of your comments first, if you would like to offer them.
Sure. Okay. So I think there are two things that I wanted to comment on based on everyone else's thoughts. First, perhaps I'll say something about Ido's kind of comment of perhaps being in the minority in the panel. I'll just say that I think, like everyone else, it's really difficult and challenging these days, but always really, to have or kind of to construct panels that are fully representative or equals in how people think about things. And I have to say, because this is an ongoing situation and because of the hostilities currently going on, we had to make some changes in the participants of this panel as well. So I appreciate, Ido, the fact that you are joining us Friday night from Israel, and I just wanted to say that yes, you are in a minority on that position, but among, as I see it, at least this panel, but not necessarily kind of outside this panel, right? So I just wanted to say about occupation or let's say the law governing Gaza, a few things that we haven't mentioned. And I think the core, or perhaps like the elephant in this room at the moment, is the West Bank, right? Because we haven't really said anything about the West Bank. And how did it come to be that Gaza is this kind of isolated small area where, Israel can just kind of withdraw forces, and then, occupation ceases, but then what remains, right? And I think it is very difficult for me to look at that position that basically created what is currently Gaza, or the prison that is currently Gaza, without, thinking about the overall, occupied Palestinian territories, which include the West Bank. I think, and for many years, obviously, there was no such separation between the West Bank and Gaza. And so this is another kind of, arbitrary sort of border that is created and maintained for a reason. And the reason at the moment is basically allowing the occupation to continue in the West Bank, while Gaza is, let's say, controlled from the outside. But I think that because of its very deep connections, or even administrative connections, right, with the West Bank, Israel still maintains control over a lot of the kind of bureaucracy that runs Gaza at the moment, right, including taxes, right, including the finances, including the census, including a lot of everyday things that can still be managed from the outside or from the so-called borders, right? So, well, I understand, your position, Ido, and I do think that something did change, right, in 2005. But I think that because this was a one-sided withdrawal from a part of the occupied Palestinian territories, and Israel did maintain control over, most of the borders, including the, air and waters, including the administrative and bureaucracy that, is not fully separated from the West Bank. I think some of those responsibilities still remain. I'm not sure how important that question is, thinking about Israel's responsibilities towards, or at least the main question that we are discussing today, because I think the main principles, right, of distinction, proportionality, precaution, and military necessity would still apply. So I just wanted to add that comment, because I think it's important, again, to kind of look at the context within its broader kind of geographical scope. So that's just one comment on occupation, or what's happening in Gaza, or Israel's responsibilities toward this area. The other part of it is that, and I think this relates specifically with regard to electricity, for example, is that because Gaza was historically a part of, the West Bank, or connected with the West Bank, And during the years of occupation before the 2005 withdrawal, Israel was responsible for electricity, for example, flow into the Gaza Strip, and has repeatedly destroyed the ability of people in the Gaza Strip to supply their own or to create their own power plant that would be enough to supply electricity for the inhabitants of the Gaza Strip. And so I think occupation, yes or no, putting that question aside, in that space, when you kind of provide historically electricity to this area that used to be, let's say, even if we take your position, right, used to be occupied, and then continuously destroying, power plants within Gaza for whatever reason, right? Not even discussing that the legality of these actions. But then, if we think about the responsibility to continuously provide or supply electricity, when we think about electricity today as really necessary for human lives, right? Including water. So I think we have to look at all those facts together when we think about the implications of the legal question about the status of the Gaza Strip. And then, listening to all you, to everything that everyone said, and I have to say that I kind of agreed with almost all comments, including most of yours, Ido, as well. I was just thinking, so what does IHL have to offer to people in Israel and in Gaza who are afraid for their lives? And I'm not sure whether we can, but I don't know, for with the remaining of our time, I was just hoping maybe we can come together and think, because I don't think the gaps between our positions are particularly wide. Perhaps we disagree on some of the legalities, but it seems like we all care about people who are currently afraid for their lives and the lives of their loved ones. And I'm just wondering whether there is something that can come out from panels like ours, taking that in mind or putting that question out there for, I don't know if anyone, I don't know if it's even a fair question, but if you have any thoughts on that, I think it would at least comfort me a little bit.
That's really an excellent question, Sherry, and I hope that some of our panelists may be able to comment on it. I wanted to remind the audience that we're going to turn in about 5 or 7 minutes to questions from the audience. So if you do have questions, please put them in the Q&A box, and you will find that function at the bottom of your screen. It's called Q&A. Just type them in. Please do go ahead and send us your questions. That's a great question, Sherry. Would anybody like to take that on? That's a tough one. What does IHL have to offer people who are in the middle of a lethal conflict?
I'm going to try to bite. I think IHL on its own is a tool. It's a tool that is meant to regulate armed conflict. It is meant to balance between military necessity and the humanity and for the protection of civilian, uninvolved civilians, and to minimize the damages of armed conflict to those civilians. And it is what IHL has to offer is the general promise that states and the international community are, might not always be fulfilled, but it always be the guidance of those states and the international community with its pressure that some might think is not strong enough, others might think is too strong. At this point, I don't think the international community's pressure is strong at all. I think either I think it's fair, I think it's too low. I don't think it's strong in pressure over the sides to the conflict, and it has implications. And I think the promise is that the message that there are limits to an armed conflict, and the parties to the conflict, and states parties to the Geneva Conventions, which is basically all states in the world, are sending towards the parties to the conflict and to each other that armed conflicts have boundaries. They are not limitless, and there are rules that must be obeyed. And I'm quite sure that as much suffer as we see right now, if we haven't had those limitations, and we haven't had the military advisors disapproving certain aspects or limiting the operations, and the military commanders understanding what they're allowed to do and not allowed to do, the damage would have been much higher. And more than that, that gut feeling I talked about in the beginning would have had severe implications, immediate implications in the ground. So I'm not sure that we can promise anything day to day. IHL, at the end of the day, allows states to do a lot of things, and they allow it to cause a lot of damage. The limitations are specific, and such as proportionality and distinction are very specific, but at the end of the day, their goal is to send a message that there are boundaries to the conflict and the use of force.
That's an excellent point. And I'll just interject here. One thing that seems to support that very much is the bombing of the hospital in Gaza City. Right after the bombing of that hospital, the head of the IDF got on CNN, and there was a conversation about whose responsibility it was. It wasn't dismissed, it wasn't ignored. Facts were presented by both sides, but it was an issue, right? And of course, bombing a hospital, a civilian hospital, is a violation of international humanitarian law. So that, to me, sort of indicated that people were aware that these were real issues that, as you say, perhaps they are not of enough significance to the world yet, but they are of significance. I found that very telling. Of course, the media is a whole different, separate set of issues. But other people, I'm sure, have something important to say about this. Yes, Omar.
Hersch Lauterpacht famously said that if international law is the vanishing point of law, then laws of war is the vanishing point of international law, the point where we're not sure where law ends. And I think there have been a lot of efforts have been made to make that not the reality any longer, to make humanitarian law something that has to be reckoned with practically. But I think that it's really important for a moment to stress how adherence to these norms can actually be promoted. And Ido, I think, pointed to one way, and I think that is military officials, as they are undertaking to take decisions in real time about what they should do, factoring in what their obligations are. And that's a crucially important piece of the puzzle. Also important, albeit I think less consequential, is the possibility of accountability down the line, which is a topic of its own, which we may address later if there's time. But I think that we shouldn't understate the crucial importance of third states weighing in over the course of the conflict, pressing the parties to articulate with specificity what their aims are, to articulate with specificity their justifications for particular actions, and not to accept or to issue a blank check with regard to actions on the ground. I think that if international humanitarian law is to have force, we cannot simply say, well, we'll figure out the lawfulness of this once the smoke clears after the fact. If we do that, we'll have rendered the vanishing point far closer to us than any of us would wish. And to my mind, this is one of the great frustrations about the kind of messaging that's coming from the Biden administration, as well as others. There needs to be far more scrutiny of what is happening day in, day out, just as there was justifiably unequivocal condemnation of what Hamas did. What we need to be hearing is much, much more careful parsing of what Israel is doing day to day in the court of public opinion that governments are, at the end of the day, jury members of.
Thank you, Omar. Does anybody else have a comment or want to chime in here?
And I can just briefly add, I think the others have said, what I would say, but just to say that I think this is a real test of the rules-based international order. I mean, I think we're seeing a situation where, many of the most basic principles that have been in place for decades to protect civilians from the perils of war are being directly, flagrantly, and openly violated, right? And I think it's critical for not just Israel-Palestine. I mean, let's be clear. We have a situation where parties are, threatening to commit further mass atrocities. They're putting it out there. We're not seeing enough from the legal community, from leaders to clarify the importance of these rules, which matter not only for Israeli and Palestinian civilians, but I think they matter for civilians everywhere in the world we have conflict. If rules don't matter here, they won't be taken as seriously elsewhere. So I think we really have an important moment. And I think it's the impetus behind this panel to sort of be clear about what the rules are and why their violation matters.
Thank you very much, Omar. We Christian, were you going to say something?
Yeah, I just wanted to, something I always tell people when, they ask about the efficiency of these rules, and Ido kind of touched on it, was like the impact of IHL is really difficult to quantify, because in most significant success situations, they're unobservable because things did not happen. So in other words, like, it's challenging to measure events that have been prevented from happening. We only see this stuff after it happens. So I do think it's always important for people to understand that sometimes IHL works and we don't even know that it works because things didn't happen. Going to Ido's point about people being advised that something might be unlawful or giving their legal opinion on it, and it stops an atrocity from happening. But obviously we don't know that because it didn't happen. And no one's going to promote someone saying, hey, we were going to do this, but we didn't because of IHL, because no one's going to do that. No one's going to say that.
Thank you, Christian. That's really helpful. We do have a question from the audience. Someone would like us to return to the very first question we formally asked, which was about the difference between, and we've already touched on this, everybody's already touched on this, but I'm going to ask you if you want to elaborate on it. The difference between a non-international armed conflict and an international armed conflict, and what the implications are. Why does that make a difference? From an international humanitarian law perspective, if anybody would like to say a little more about that.
Yes, I would. I think there are many preliminary questions to make such a classification of conflict analysis. First of all, the question of belligerent occupation is automatically places the conflict within international conflict or non-international conflict. So even if we go from that point of origin, we might already have an answer about the classification of the conflict, whether or not it's a state versus a non-state armed group, which usually would be considered as a non-international conflict or a cross-border conflict between Israel and Hamas, which might be defined as an international armed conflict, which is also being supported by the Israeli High Court of Justice in the targeted killing case. At the end of the day, it doesn't really matter, because most of the applicable rules, most of the important rules related to the conduct of hostilities are customary in nature. And therefore, proportionality and distinction and precautions that the parties must take are applicable regardless whether or not this is an international or non-international armed conflict. some aspects that might be relevant are whether or not an international armed conflict, we have the notion of combatancy, combatants and combatancy immunity, etc. But because Hamas is a non-state actor, then its fighters are not combatant to begin with. They don't have that status. They don't have that immunity. So at least from my perspective, my analysis, that even that aspect become redundant and irrelevant because there is no combatancy status. And at the same notion, if I jump a little bit to a different question, the question of the status of the hostages, then they are hostages, and I don't refer to them just as hostages. They're hostages. There is no prisoner of war status in that context. They are being held by a non-state armed group. They are hostages. We have, according to the current information today, 229 hostages are being held. They are not, none of them are prisoners of war. If they were prisoners of war, they would have been entitled to visitations from the ICRC in accordance to IHL. They would have been entitled to proper shelter, proper food, proper hygiene conditions. And I mean, the Third Geneva Convention is one complete convention regarding to how you should treat prisoners of war. Hostages don't receive that. Hostages, by the nature, taking hostages is a war crime, and they should be unconditionally and immediately released. And pending their release, they should receive visitations from the ICRC. They should receive proper treatment, and take into account that there are infants there. There is a 9-month-old baby there being held. There are children, there are elderly persons, older persons, and you have people with disabilities over there, and they must be immediately released. And holding them is not only a war crime, this is also enforced disappearances, which is a crime against humanity. And that framework is irrelevant for the classification of the conflict. This is a situation that must be resolved immediately. I don't want to jump through all of the 5 questions. I'm gonna leave it to later on, but if any question comes up, I will add my opinion as well. Thank you.
Thank you very much, Ido. The ICRC has been referred to several times. Just for those who may not know that acronym, it stands for the International Committee of the Red Cross, which is distinct from the American Red Cross. Christian can elaborate on that if he chooses, but they are, of course, brother-sister organizations. And the International Committee on the Red Cross, I might add, in a public statement has called for the release of the hostages, immediate release of the hostages as well. Since we have just a few minutes left, I'd like to offer everybody on the panel an opportunity to make a concluding remark. We've got about 6 minutes, so maybe about a minute apiece. I'm going to start with Christian.
Yeah, I guess my concluding remark would be that as professionals in international law, I think it's just incumbent upon us to make sure that people understand the rules that we're talking about, and not just our own legal conclusions on what the rules say to facts. I think it's important for people just to understand the baseline of what these laws are, and because that allows them to take it into society and hopefully have a better discourse. Because when society is divided at the same time, people's whose needs, such as civilians and the innocent, are often, we might think that we're promoting them, but we are also might be disregarding the other side that we might not be advocating for as well. So I just think it's important for us to realize that we should be educating people about the law and not just giving people conclusions on what we think the law says to certain facts.
That's great, Christian.
So I just wanted to make sure that's clear.
And definition of terms such as military necessity, proportionality are critical to continuing the discourse. Omar Shakar, would you like to make a concluding remark?
Sure. What I want to say is, as the practitioner here, and I know there are a lot of academics, we are seeing carnage and bloodshed at a scale that's unprecedented in modern Israeli and Palestinian history. So the academic debate is critical. It's important because we need the information out there. But I think we need to focus at this moment as much as we can to use our voices to underscore the necessity and urgency of protecting civilians. You mentioned earlier, no apparent military target in our language. This is when we've done weeks and months of investigating of prior strikes, where we've been able to show that there were no combatants in an area that obviously the Israeli government has the duty to provide the information, but this isn't a vacuum, right? This is a decades-long pattern of using very well documented unlawful excessive force. We can't make determinations on specific strikes, but we know from the scale of devastation, from reducing entire blocks and large parts of neighborhoods to rubble, that there are really serious violations by all parties. Parties are directly saying in plain language, heads of state and ministers, that they're going to hold an entire civilian population accountable for the action of really clear black letter, execute hostages by Hamas. We just need to be unequivocal on all abuses. There is a real prospect of further mass atrocities. As lawyers, as people of conscience, we need to use our voice, not just in these panels, but in the public world. Stop, end the madness, end the insanity now.
Thank you, Omar. Ido.
Thank you. I think that it is very, very important to examine this current conflict as kind of a test case for international humanitarian law and international law in general. And I think the equivalent would be, just as when I claim my position that Gaza is not under occupation, and clearly there are different positions on that, several of those positions are basically a development of international humanitarian law and international law, and adjusted to the reality on the ground. Some might say that such a development is kind of evolutionary for international law, and others might say that this is, a way to ensure that there is no vacuum under international law. Now, I've been saying for years that international law is allowed to have vacuums. International humanitarian law especially is allowed to have vacuums in it because it's not meant to govern everything. We have other sets of legal frameworks that can complete the aspects, and we don't have to stretch international humanitarian law to cover everything that we want to cover it. So this is another example, the current conflict that we have, of how international humanitarian law reacts to the reality of the extensive use of, on the one hand, of human shields and hiding. The IDF spokesperson just said that they have proof that Hamas headquarters are embedded within and underneath Shifa Hospital. And so how IHL can react to the fact that hospitals are not just placed next to military object, a hospital becomes a military objective by the fact that it's being used and its facilities are being used by a non-state armed group. And clearly, we don't want to see a hospital being bombarded. And we don't want to see that kind of level of collateral damage. And we must do everything we can to stop it. But when we analyze proportionality, and human shields are being used to increase that proportionality, I'm not giving an answer now because the answer is way more complicated than that. But we need to think, if IHL can develop in accordance to occupation situation, how should it develop in that kind of warfare by a non-state armed group? And what would be the implications, keeping in mind that IHL, as I said before, is a balance between allowing the states to operate, but trying to keep the damage limited. And that kind of discussion is something that I want to have, I think we have to have, and see what is the next evolution of IHL in accordance to this test case while keeping in mind that our main goal is to limit the damage to uninvolved civilians.
Thank you very much, Ido. Omar Dajadi?
I just would like to make 2 points in closing. The first is, in a sense, a response to the point that Ido just made. Certainly, IHL is always evolving, and there are new challenges that it has to respond to. But as we think about urban warfare as a context in which it needs to unfold, we've got to also bear in mind the factual circumstances in play. The Gaza Strip is a space about double the size of Washington, D.C. It is small. To say that Hamas fighters are embedded within the population can sometimes cause us to lose sight of the fact that there's really not an alternative to them being embedded within the population in a space so small. Such circumstances can be a function of reality, not just strategy. And when we are thinking about the core mission of international humanitarian law with an emphasis on the H, humanitarian, we shouldn't forget that protecting civilians is right at the core of it, and that we've got a presumption that an object, unless decisively proved to be a military objective, is civilian, and that is intended to protect. But the last point I want to make is that while our conversation is focused on how the legal rules that are in play can help to protect civilians in a situation of this kind, and how they should protect it, I also think we shouldn't forget the question of why IHL exists. And that is in part because of our evolving view that total war is simply unacceptable, that it places too many burdens on civilian populations, but also that total war is ineffective, that total war results in a deepening of long-term conflict. And if we can see a case in point, I think it is what has unfolded in Israel-Palestine over the last 25 years. Israel, if you look at the historical record that I began by recounting, has suggested that disproportionality is a means of achieving deterrence. And that may be true in the short run. But what we have seen over the last weeks, again, echoing Omar Shaker's important distinction between explaining and justifying, but what we've seen over the last weeks is that it is an abject failure as a means of conflict resolution. And as we move from identifying the rules that govern how this conflict must be prosecuted to how we end it, we shouldn't lose sight of how dangerous each and every airstrike is to the prospects of a transformed situation on the ground in Israel-Palestine.
Thank you. Shiri?
I actually think that Omar's words are really appropriate to the closing, because I couldn't agree more that I think where we should focus our attention right now is on ways to mitigate the cycle of violence, and there is no other solution, of course, than a political one. And I think that sometimes the entrenched discussions about what IHL permits or what it doesn't is just a way to kind of sidetrack the actual urgent debate about a political solution that I think this kind of outburst of violence that doesn't seem to that seems to only be escalating is depressing and almost without any kind of legal solution in that sense. So I think whether we agree or disagree on the 5 questions that we posed for the discussion, I think Omar's words that we really need to think about an end to this cycle is how I would also like to end the debate. And if you allow me to add another poem, I wanted to just 2 lines from Polish Nobel Prize winner Wisława Szymborska. And she wrote that history counts its skeletons in round numbers. So 1,001 remains 1,000, as if the one had never existed. And so this is a part of a beautiful poem that's called Hunger Camp near Jaslo, coming out from following World War II. And I think, it kind of came to my mind while we were talking, at least in the kind of last couple of, especially in the last few minutes, thinking about our obligation as international humanitarian law practitioners or scholars, that this is really the heart of IHL, as at least I hope it could be, right? As a non-cynical way to look at the law as a way to protect people and to protect that one person that history will never count, right? As this one person that was burned in their home or buried under the rubble, whether in Israel or in Gaza. And I think that we owe it to those people and to the people that will die tomorrow, that we will find and we will pressure the international community to assist in finding a political solution, because there is no other way to mitigate, I think, this cycle of violence.
Thank you. On behalf of the American Society of International Law, Lieber Society, and the DC Bar International Law community, I would like to thank all of our panelists for a very interesting and important discussion, and one that I hope that we will continue. Thank you so much. Thanks everyone for attending.
Thank you.
Thank you.